Just for sake of time, I'm going to go ahead and introduce both of our speakers today, and then I will turn the time over to Ms. Amy Goetz, who will present first. So to introduce Ms. Amy Goetz, she is a private attorney and founder of the School Law Center, an education law firm representing students and families in Minnesota and Wisconsin. Her practice includes work on cases involving special education, student discipline, discrimination, including harassment, bullying, juvenile court referrals from schools, general education, athletics eligibility and participation, restraint, and seclusion. Ms. Goetz has successfully resolved hundreds of student and family claims through formal and informal means, obtaining favorable results that have significantly impacted the lives of children and their families, as well as changing and improving school and legal systems. She is a mediator for a number of state education agencies and due process hearing officers in Utah. She is a trainer and teacher, having presented numerous seminars on various education law topics to parents, attorneys, judges, and other groups, as well as regular lectures in education and law classes in the Twin Cities area. She has worked in education law since 1995, first as a staff attorney with the Minnesota Disability Law Center in Minneapolis, then as a complaint investigator at the Minnesota Department of Education, and finally as a student and family lawyer in a private law practice. Ms. Goetz is admitted to the Minnesota and Wisconsin state courts, the Minnesota Federal Court, the 8th Circuit Court of Appeals, and the United States Supreme Court. Recently, she received a national award from COPA or COPA. Her background is in legal services, working for 19 years on matters involving family law, child custody, adoption and foster care, housing, and government benefits. Ms. Goetz is the proud parent of 2 beautiful adult children with disabilities. We also have Jose Martin with us today. Jose is a partner with the School Law Firm. Oh my goodness, I'm tongue-tied. He is a partner with the school law firm of Richards, Lindsay, and Martin, LLP in Austin, Texas. His practice focuses exclusively on disabilities issues and litigation affecting public schools, including special education consulting and litigation under the Individuals with Disabilities Education Act, or IDEA, Section 504 of the Rehabilitation Act of 1973, and the Americans with Disabilities Act. Mr. Martin graduated from the University of Texas and the University of Texas School of Law, and in April, he will have been a practicing attorney for 30 years, all in special education. He has presented in more than 40 states, from Hawaii to Florida to Alaska to New Jersey. He has been partnering with the Wyoming Department of Education to bring quality professional development and guidance on special education issues since 2007. And so welcome to both of you, and thank you both so much again for all of your time and preparation. It is now my distinct honor to turn the time over to Ms. Amy Goetz.
Thank you, and thank you all for participating today. Thank you for inviting me to participate in this very meaningful training series and giving us some really interesting topics to talk about. We were chatting before the series began here today about how these are really hot topics. Folks are very interested in how it is that we respond to the lack of progress given these really unusual circumstances we've all lived through the past couple of years, what the courts are requiring, how hearing officers are dealing with these questions, how our state and federal departments of education are responding to questions about what we ought to do. I think it's pretty clear that we all understand that there are varying levels of impact on not just students, but teachers and administrators. And it's been a really difficult time. And I think that for the most part, people have done their best in very difficult circumstances. My overall response to what's occurred and questions I get from parents is just that for the most part, people are doing the best they can in very difficult circumstances. I think that we've gotten some good guidance from the Federal Department of Education on what we ought to be doing to respond to the difficulties that students have faced, and how to bring forward some remedial instruction and additional supports and services to address their needs. I'm most impressed by the Department of Education's use of the term mental health supports. We haven't seen that forever in the Department of Health, in the Department of Education's guidance. The IDEA, as you know, doesn't use that term. It uses the term individual, group and family counseling, social work services, psychological services, behavior supports. It uses those terms to describe what we might otherwise know as mental health services. But in the guidance with respect to what to do to respond to COVID shutdowns, the Federal Department of Education has finally unabashedly started to use the term mental health supports. And I, for one, am very glad to see that, because I think it has been a disservice to avoid using what is an obvious term to identify both the kinds of disabilities that many students in our schools have that impact their educational performance in a whole variety of ways, sometimes very, very significantly, and especially now to respond to how COVID and the impacts of the last 2 years have affected them. So those are my initial overviews. Let me start with my presentation in terms of what I've prepared. There is a handout that follows this outline, and I hope that you will have access to it and pull it down and read it, because it provides a lot more information than I'll be able to cover today. If you have questions, please submit them. We're glad to respond to those later in the program. At the end, we're going to preserve some time for questions and answers, and so glad to respond to questions. They're always useful. They're always helpful to discuss, and so feel free. So every discussion of the obligation of what we should do to respond to a student's lack of progress has to start with an understanding of the expectation for how much progress is enough, or what is a free, appropriate public education? What is the measure of progress that is sufficient to pass muster under the IDEA? A free, appropriate public education, as you know, is required by the IDEA. It's also required by Section 504. And it's very clear that recovery services are to be provided when a free, appropriate public education is not delivered. So what is a free, appropriate public education? The purpose, the primary purpose of the IDEA tells us that that's why we have this law, is to ensure that all children with disabilities have available to them a free, appropriate public education. And that purpose statement goes on to tell us what a free, appropriate public education, what its objective is. And it tells us it is to emphasize special education and related services designed to meet their unique needs and prepare them for further education, employment, and independent living. So those are the targets of special education. That's the primary purpose of it. That statement gives us pretty broad strokes, but a basic understanding of what it is, what that FAPE is. It's never been extremely well defined, frankly, by Congress or by the courts. But we'll talk just a bit about how both Congress and the courts have attempted to define that term. The statute, which is passed by Congress, actually has a definition for free, appropriate public education. It defines that term as having been provided at public expense, under public supervision and direction, and without charge, meeting the standards of the state educational agency, including an appropriate preschool, elementary, or secondary school education, and provided in conformity with the IEP requirements under the law. So again, pretty broad brushstrokes in terms of a definition. We've gotten a little bit more meat on those bones from the courts. The first decision that is the law of the land, or was until the last couple of years, was a case called Board of Education versus Hendrick-Hudson Central School District versus Rowley, Supreme Court case from the United States Supreme Court of 1982. And the Supreme Court there defined the term free appropriate public education as being provided when a student's IEP is, quote, sufficient to confer some educational benefit, end quote. The controversy over what exactly that meant brewed, I think, from 1982 and is still brewing today. The justices on the Supreme Court reheard the question of exactly what is a free appropriate public education in 2017 in a new case called Andrew F. versus Douglas County School District RE1. And there at oral argument, I think it was Justice Breyer commented that the Rowley standard, that sufficient to confer some educational benefit, was that there was a significant amount of controversy over what that meant, that parents were focusing on the term educational benefit and schools were focusing on the word some. And so he saw the court's job as trying to reconcile those two pretty divergent emphasis by all the parties to IEPs. So the court then in Andrew F. gave us what I think is an updated standard. They told us that the standard that had been decided in the court below, which is the 10th Circuit Court of Appeals, that's your Court of Appeals, and it was decided by, and the opinion was written by now Supreme Court Justice Gorsuch. And he continued what had been an established standard in the 10th Circuit for defining essentially how much progress was sufficient to pass muster as providing a free appropriate public education, and defined that anything more than a de minimis amount of progress, anything more than a de minimis amount of benefit, educational benefit, would do. The Supreme Court directly rejected that standard. It was, they said that the actual standard from Rowley was what they called markedly more demanding, that the approach to a free appropriate public education, what they called the de minimis standard, that actually allowed students, they said, to sit idly awaiting the time they were old enough to drop out. Those are the words of the US Supreme Court in 2017. They elevated the standard by the focus on progress, not just benefit. They decided that all students are due the chance to meet challenging objectives. And for those not fully integrated in a general education where passing grades are the typical measure of progress, that their IEPs must be appropriately ambitious in light of their circumstances. So this analysis, sufficient to produce progress, is now a required and key component of the determination of how much progress is sufficient to pass muster, should result in a more robust and demanding standard by which to assess the adequacy of progress for every student on an IEP not fully integrated into the general ed classroom, as well as to give us more accessible language for IEP teams to discuss and determine important issues of FAPE for students. It was interesting. I looked through all the 10th Circuit Court of Appeals cases on denials of FAPE to look for cases in which the court applied the FAPE standard and made a determination about whether a student was entitled to compensatory education, and could not find not one case in the 10th Circuit where the court ordered compensatory education. And I frankly have to chalk it up to the fact that there was such a low standard, that de minimis standard, that now does not any longer apply. So I would be really leery about applying 10th Circuit case law that assesses the right to a FAPE because of the outdated and now reversed and superseded standard that is just too low to actually be accurate. So, of course, every court in the nation after 2017 and Andrew F. is required to apply the Andrew F. determination. Any progress at all is no longer sufficient to pass muster under the new standard. And so keep in mind that that standard, the de minimis standard, was directly rejected and reversed by the Supreme Court. Section 504 also has a free appropriate public education requirement. Not at all a well litigated nor well understood concept. I couldn't find cases where a court or at any level in any state has determined what a free appropriate public education under Section 504 actually means. The regulation for 504 doesn't define, requires a free appropriate public education. The regulations define appropriate education as the provision of regular or special education and related aids and services designed to meet the individual needs, educational needs of, and we still use the term handicapped persons in the regs, as adequately as the needs of non-handicapped persons are met, are based on procedures that satisfy the requirements of Section 504. And it goes on to say that implementation of an IEP developed in accordance with IDEA is one means of meeting the standard, that a recipient, so a school, can place a person with disabilities or refer a person to for aids, benefits, or services other than those it operates or provides as its means of carrying out the requirements, but they remain responsible to ensure the requirements of the law are met. No further definition of what appropriate education means, how much progress is enough. Some nod to the IDEA as one way of meeting the requirement. So the question of how IDEA and 504 intersect and relate is, I think, still an unsettled and really quite interesting question that we will continue to see evolving in the courts over the coming years. At this point in time, there is an evolving line of cases that say IDEA and 504 are separate and distinct. They each have their own obligations. Children with disabilities are entitled to protections under both IDEA and 504, as well as the Americans with Disabilities Act, and determining which rights are fulfilled or what obligations exist under each of those three federal laws to students with disabilities is, I think, fairly said to be not a settled question. And one that has led to, I think, a significant amount of both confusion and oversight of the strength of these two non-discrimination laws, the 504 and the ADA. In my view, they've been pretty much eclipsed by special education, and they've laid fallow for decades. And they're coming to life now, and some courts, including the Ninth Circuit Court of Appeals, has taken the position that they are separate, viable, distinct, and equally applicable laws to protect students with disabilities, and that even if a school district fulfills its obligations to a student under IDEA, it may still run afoul of its obligations under Section 504 and the ADA. So special educators and administrators are wise to become familiar with the requirements of Section 504 and the ADA, and to comply with the requirements and to respect the protections that exist there as well as under the IDEA. So there hasn't been a 10th Circuit Court of Appeals case applying the FAPE mandate under 504. There hasn't been a United States Supreme Court case applying the FAPE mandate of 504, but the Supreme Court did decide a case in 2017, the same session as Andrew F., that gives us some idea about what the Supreme Court thinks are the differences between IDEA and 504. The Fry case was about a young student who needed the assistance of a service animal, a service dog at school, and the district refused to let her have her service dog. And so that was the source of the controversy. It went all the way up to the US Supreme Court on the question of whether before the student and her family could access the federal court to ask for relief, that is an order that the service dog named Wonder could come to school with the child, that they had to first go through the administrative process. And the US Supreme Court said, no, the question of your access to school with a service dog is not a question related to a free appropriate public education. Only questions related to a free appropriate public education are questions of special education rights and required to be exhausted through special education procedures. And so a couple of things that were really interesting though about Fry in their analysis of the distinctions between these laws is that they recognize very clearly that the IDEA does not prevent students from asserting claims under Section 504 or the ADA. So they also recognize that, let's see, that there's been a long history of misunderstanding of how these laws interrelate and interplay. They said that under the ADA and 504, students and their families can seek redress or relief for violations of anti-discrimination mandates by bringing in suits for injunctive relief, asking a court to order a school district to do or stop doing something, as well as monetary damages. And monetary damages are not available as relief under IDEA, which is a pretty significant line of demarcation in terms of what relief can be available between those two laws. The 10th Circuit Court of Appeals has not decided a case regarding the application of a free appropriate public education. Sorry. So compensatory education services have been recognized for some time as kind of the coin of the realm. Interestingly enough, the first kind of relief, in addition to improving a student's special education program, improving a student's evaluation, those were really the first kinds of relief that were recognized by the courts. The first kind of retrospective relief recognized by the court were private school reimbursement claims. And a case called Burlington got to the United States Supreme Court in 1982 that set the standard for reimbursement when parents remove their children from public schools over disputes regarding the benefit they were getting from special education, move them into private schools, and then asked the public schools to pay the tuition and the costs for the private education. Interestingly enough, I thought and this was one of the lessons I learned in preparing these materials, the whole concept of compensatory education was born in the desegregation lawsuits. Milliken versus Bradley, the United States Supreme Court in 1977, in looking at how to restore children who had grown up, been educated in segregated facilities on the basis of race. When the questions came up about how to make that right for them, the concept of compensatory education was born. So that's where the genesis of the concept is. It was understood to be necessarily determined by the nature and scope of the violation remedial in nature, and designed to, quote, restore the victims of discriminatory conduct to the position they would have occupied in the absence of such conduct. So it seems like a natural extension to apply this concept to the IDEA, which was enacted to correct really the exclusion of students with disabilities by the public schools. So for parents who can't afford to remove their children from the public schools, for parents who don't have access to a private school that is appropriate, that provides the kind of special education related service their child needs, for parents who just don't want to abandon the public schools, but want the public schools instead to serve their children, compensatory education has really become the coin of the realm. And so for those parents that don't remove their children and put them in private school, actually the Circuit Court of Appeals that I practice in, the 8th Circuit Court of Appeals, first recognized compensatory education is what we call the poor man's corollary to private services. The private services that were recognized by the Burlington Court, the reimbursement for private school tuition that was awarded in that case for families who couldn't afford private services as relief. It was really thought to be an extension of that Burlington decision. And both the Burlington Court and the Minor Court, Minor versus Missouri was the name of the 8th Circuit case in 1986, recognized that compensatory education, just like reimbursement for private school tuition, is not damages. It's not like giving money damages for injuries, like in a personal injury kind of a claim. The court understood, and this is the Minor Court in the 8th Circuit, that the child's right to a free, appropriate public education, the parent's right to participate fully in developing a proper IEP, and all the procedural safeguards would be less than complete, a result that Congress didn't intend by authorizing the grant of appropriate relief unless the relief of compensatory education were available. The court said, we cannot agree with the defendants. They should escape liability for these services simply because Claude Minor, the dad, was unable to provide them in the first instance. We believe such a result would be consistent neither with Burlington nor the congressional intent, like the retroactive reimbursement in Burlington imposing liability for compensatory education service on the defendants merely requires them to belatedly pay expenses that they should have paid all along. And that language, that last phrase comes from Burlington itself. Here as in Burlington, the Minor Court went on to say, recovery is necessary to secure the child's right to a free, appropriate public education. We're confident that Congress did not intend the child's entitlement to a free education to turn upon her parents' ability to front its costs. So let's see. Oh, sorry, I'm behind in my screen advancement here. Andrew F. Law of the Land, Supreme Court, markedly more demanding, requires progress, reasonably calculated to enable progress. And the court went on to say that the progress has to be appropriate in light of three things. What's the child's present level of performance? What's his or her disability? And what's his or her ability? It's an individualized analysis. They were very clear. There's no one standard. Challenging objectives, ambitious goals are required. So Section 504 is an equal access, equal participation, equal benefits, and discrimination prohibition law. The Fry case we talked about, 504 and ADA coexist with IDEA. Not every educational harm has an IDEA remedy. We talked about damages and injunctive relief being two that the court focused on. Compensatory education with its roots in school desegregation to restore students to the status they would have enjoyed absent discrimination. Any appropriate relief is what the IDEA says. Courts are empowered to award for violations of IDEA, for deprivations of rights. private school reimbursement, compensatory education, to pay expenses should have been paid all along, and to restore the lost benefits of a FAPE. There are two ways to calculate compensatory education, say the courts and hearing officers who have looked at the question. Is it a quantitative approach, replacement for a period that's equal to the period of deprivation? So an hour for hour approach, a formula-based approach. How many days did the student miss? How many hours did the student miss over how many years? Multiply those figures and come to a conclusion about how many hours should be provided to make up for that. The other is the qualitative approach. It's more flexible. It's based on individual needs. There's a spectrum of compensatory relief. I think it better reflects the IDEA mostly because it's an individualized assessment. So COVID impacts. If there are no services to the general population, the U.S. Department of Education has been clear. No services are required to be provided to students with disabilities. And so there is, I think, and will continue to be, a lot of what I call a play in the joints. I think there's going to be a lot of forgiveness in what hearing officers and courts do with claims that children have not gotten exactly everything that they went into the pandemic receiving throughout the pandemic. I still think that hearing officers and courts will be responsive and state departments and state complaints to claims that children have suffered a loss of progress. I think we'll be applying the Andrew F. standard, but I think that there's going to be an understanding that most schools did the best they could with the difficult circumstances, and that there was a measure of impossibility in terms of maintaining services. Certainly when schools shut down, when schools went virtual, students on IEPs didn't get the same level method of service, and many didn't get the same benefit. And so the objective has got to be to work together across the table between parents and educators to figure out how students suffered, which students suffered, who fell behind, who didn't get the benefit of the education that we all wanted them to get during the COVID pandemic and the shutdowns and the changes in services that we wanted them to get, and what can we do to restore to them the benefit so that they can catch up and resume the place that we intended them to have absent those circumstances. When there was any services to the general population, students with disabilities were entitled to a FAPE. To the greatest extent possible, in an IEP or 504 plan, impossibility excuses temporary modifications. The teams decide, IEP or 504 teams decide. It's an individualized determination whether and to what extent services are needed to make up for lost skills. It's got to be tailored just like the IEP is. Address for early intervention services, address for extended absences, for inaccessible services, whenever progress is reduced, services are delayed, services are changed, whenever needs have changed. The department's been very clear. Parents, educators, and administrators should collaborate creatively. That's the term they use, to meet student needs. Dispute resolution systems remain available when those efforts fail, but they're very clear to emphasize that creative collaboration is what's necessary, effective communication, meeting with parents, coming together as an IEP team, brainstorming about what children have lost and how to measure that, how to identify that, and getting creative in a collaborative way about making that up. So compensatory services is one means of recovery, student and family re-engagement, parent support, educator support. Here's the other big lesson I learned. Learning acceleration, said the U.S. Department of Ed, is better than compensatory education. designing environments and conditions to overcome adverse effects, responding to social, emotional, and mental health needs, especially for those who lost the most. Tailored to differentiate instructional pathways with high expectations, rigorous accountability, educational equity. Acceleration rather than remediation, building in the makeup services to a student's current IEP rather than piling on additional compensatory services. And they said evidence-based tutoring practices are key. I thought that was great. And they gave us some clues about the most effective tutoring, trained educators, high dosage during the school day, attendance and focused work time if it's not during the school day, and aligned with evidence-based curriculum. General ed recovery services, enhanced IEP services, enhanced ESY, and compensatory services. Those are the 4 categories of recovery services that have been identified that are available for us to talk about and deploy. The department has recommended a quick diagnosis of the gaps in skills and concepts, expanding days, weeks, or years, summer learning, prospectively addressing past failures or the inability to provide appropriate services, looking, of course, at present levels, previous rates of progress, prior services, proactive mitigating measures using sound educational judgment, and to make sure that we understand that provision of compensatory services doesn't draw into question the school's good faith efforts. That's all I have. Thank you.
Amy, thank you so much. That was a lot of information. Again, she has done a wonderful job of giving you even more than what's in her presentation, and it's in an outline form. And it's in those handouts just right below her slide decks in that you received. If you didn't get that, we can repost that in the chat if you joined us late. I'm now going to turn the time over to Jose for some remarks, and I will just turn it over to you, Jose.
Good afternoon, everybody. I agree with a lot of what Ms. Goetz indicated, except, of course, I want to point out where I think that there's remarks upon which there's a healthy diversity of opinion. I don't really think a whole lot about the Department of Education using the term mental health supports, that really means anything substantive. I think they mean there's going to be an expectation that students that are emerging from COVID may have had some level of trauma in when the school's closed and some level of trauma in returning, and particularly students with disabilities that have more difficulty navigating those types of changes. And that thus there's going to be an expectation that children may require some level of mental health support. There's 2 ways to look at that statement. The way that I kind of look at it is that they're simply expecting that IEP teams should be ready to provide the types of related services and supports that are listed in the related services regulations, the counseling, potentially parent counseling, maybe more intensive counseling services. Another way to read it is that there's an expectation that children will require mental health services also to be provided from other agencies, from state, local, and regional agencies. Now, on the NDRU piece, I disagree that NDRU either overrules or supersedes Rowley, and I think that the federal court cases in 2017 have made that clear. Rowley has its place and NDRU has its place. We need to remember a couple of things about NDRU. One is that it dealt with a 10th Circuit that to me had an anomalous standard for FAPE. This idea of anything above de minimis is a FAPE is taking that some statement, some educational benefit statement in Rowley too far. And in fact, I remember looking back then when the NDRU decision came out, if you look at really all of the other circuit courts of appeal, they didn't apply that skinny standard. In fact, the most common standard that was applied was that some educational benefit under Rowley, in fact, meant really more than trivial, that it had to be meaningful. Like, for example, my Fifth Circuit Court of Appeals in cases almost immediately after Andrew said, for us, this means nothing because we all always looked at some educational benefit as imposing a meaningful benefit standard. And they said it's consistent with the Andrew formulation. Another point that I want to make about Andrew is that Andrew touched on the fact that the Rowley case dealt with a fully mainstream student and dealt with the idea that for a fully mainstream student, a FAPE can be measured primarily by whether they're normally advancing from grade to grade. And all that Andrew said is that standard isn't terribly useful when you're looking at a child with more significant disabilities that functions on a modified curriculum, and that standard isn't so helpful. And thus, they went for a standard that is, in fact, more applicable in those types of situations where the students aren't fully mainstream. That's the appropriate progress in light of the child's circumstances. And thus, we get a standard that is responsive to how Rowley analyzed it with respect to mainstream students. It's also responsive and I think consistent with how circuit courts applied it after Rowley. I think the 10th Circuit standard was an anomaly. And I think that what you should look at is, I completely agree with a statement that you cannot rely on just a student making bare minimum progress and expect that that's going to be sufficient for FAPE. That progress has to be meaningful, and it has to be meaningful in light of the child's circumstances, in light of their abilities, in light of their disabilities, and any other circumstances that may impinge on the student's progress. Yeah, by the way, I like the mention of the fact that Justice Gorsuch, who now sits on the Supreme Court, is in fact the originator of this half a hair above a hair standard. That's kind of how I read it. De minimis is a hair. So if you have a tenth of a hair above a hair, you've met the FAPE standard. I always thought that that's not going to work. That's just overreading the sum qualifier in Rowley. I kind of have a little bit difference of opinion on FAPE under Section 504. I wanted to make a couple of comments about that. I mean, the regulations do define FAPE under Section 504. And they indicate it's about meeting the needs of the students with disabilities just as well as you meet the needs of the others. It's very clearly a comparative standard. But I wanted to point out something. Ms. Goetz indicated there's really no cases that talk about FAPE under Section 504. I'm going to venture an answer as to why. Because we're not sure 504 FAPE is a thing. Okay. Remember, in Alexander v. Schott, the Supreme Court said, Section 504 is not a statute of affirmative obligations. It's a statute of prevention of discrimination. It's a prohibition statute. It prohibits discrimination and punishes agencies that engage in discrimination. It is not meant to provide affirmative action for students. Yet the 504 regulations included the FAPE requirement. So an untested concept is, what is the basis for the affirmative FAPE requirement under Section 504, and does it exceed the scope of the statute? And I think courts, if they have to confront the FAPE issue, are going to have to confront that biggie. That's a big legal question that hasn't been answered in nearly 50 years since 504 came out. I don't agree, by the way, that 504 imposes an equal benefit standard. It does not. You meet the needs of the student as well as you meet the needs of the other, and let the chips fall where they may. Once you're providing accommodations that even the playing field and give the student basically a competitive fighting ability, it's up to the student to duke it out. And there's no standard that imposes some sort of an obligation that the benefits or the results that the student will receive under Section 504 are the same as the results of others. Equal access, yes. Equal opportunity, definitely. Ensuring that there's not denial of exclusion, absolutely. And I've got to say, I'm going to disagree with something that Amy said, and she's going to love it. And it's the following. She said the COVID impact, part of it is if no student gets services during a COVID closure, then students with disabilities don't get services either. And she correctly is stating that that was in the March 2020 guidance from the Department of Education. I partially disagree with that Department of Education guidance. I think it's correct under 504. If other students aren't getting any services, you're entitled as a 504 student to equal nothing, and that's going to be nothing. But IDEA is not a comparative standard, and it's not a non-discrimination law. If the other students aren't getting anything, the IDEA student, to me, is still entitled to a FAPE. And if the school is not providing any services during the period of school closure, you're going to have to provide lots of compensatory services later. So I actually disagree with this underlying notion of the Department of Education that a school that provided nothing to students in general during a period of COVID closure have to provide nothing to the IDEA students. No, I think they have obligations with respect to FAPE to the IDEA students. That's it for my response comments.
Well, thank you both. I have in the agenda last time, it was asked that we just take a short break, but I'm not sure if everybody, it's mainly for our presenters, and I'm not sure if you guys would like to take just a few-minute break or if you want to just continue on.
I do not have a problem with pressing on.
Nor do I.
I'm getting some questions, so I'm thinking that by the end, we might want to save a little more time for our questions this time because we ran out of time last time. So
I agree.
Okay, well, then with that, Jose, I am gonna have you go ahead and present your slides and we will move on. And I have in the, let's see, so it is right now about 4:21. So if you'll take about that 30 minutes for your presentation, and then we'll just adjust the agenda from there.
I've got my digital stopwatch that this old man is gonna get started. There we go. Okay. Legal issues and students moving into and out of virtual settings. Boy, big topic, lots of areas. I'm gonna take this as a truncated presentation. I'm going to touch on some of these areas. They raise a lot of complexities. Obviously, these issues were thrown upon us with respect to COVID. But I've got to tell you that I've been a student of online programs even before COVID came out, because I've been very keen on the proliferation of online programs, and also I've kept up with the fact that increasingly, and this is even before COVID, students with disabilities were participating in these online programs. And I've wondered and thought and studied quite a bit about how the IDEA legal framework, one that was honestly not intended for anything other than brick and mortar schools, is intended to fit in this online education world. So I'll touch on a little bit about that. But first, mundane stuff. Let's talk procedure issues, okay? Here's a question that I had when we closed the schools down, probably around March of 2020, okay? And the questions that arose in my mind were kind of procedural questions. You know, we start with, you know, when we do things under IDEA that affect students, we want to make sure that they comply with the procedural requirements of the law. One part of Rowley that I'm sure Ms. Goetz does not want overruled is that part that requires procedural compliance even before you look at the appropriateness of an IEP. So procedural compliance is key. Rowley's still good law on that point, obviously. And the procedural question that immediately arose in my mind was, when we wholesale move all students from in-person instruction to virtual instruction due to an act of God, due to like a pandemic like this happen, are each of these moves of all of the students changes in placement under IDEA that trigger the change in placement procedures? I'll leave that question hanging. Next question is, when you move one student from in-person instruction to virtual, is that a change in placement? And what about if you take one student and move them in reverse, you move them from virtual to in-person education? And I want to explore those questions a little bit. I'll go back to the guidance that Ms. Goetz was talking about a little bit, which is the first dose of guidance from March of 2020. I'm sure Ms. Goetz knows that this was kind of recycled when what is that virus that came out? H1NV1, I don't know. The last virus that we had that was scary, not near as scary as COVID, I think, which was a few years back, they issued pretty much this identical guidance, which they just recycled and kind of put out. when COVID came up. And it says if you exclude a child from school because of COVID, because they're ill, because they're infected, or because they're at high risk because of COVID, is the action a change in placement? And the Department of Education said, yeah, if if the move's going to be longer than 10 days, which is sort of a traditional and standard formulation, right? Applicable with respect to discipline, but also outside of the discipline context as well. And they said, then you'll have to do the change of placement procedures, meaning the IEP team has to act to do it. And of course, prior written notice has to be issued that explains the action. And of course, parents retain rights to challenge change in placement. And they said for 504 student that these changes in placement have to be in accordance with the 504 regulations, which require a 504 meeting and a reevaluation, not the real reevaluation. It's mean looking at multiple sources of data to make the decisions. No prior written notice, but you have to provide notice to the parent and procedural safeguards, notice of their procedural safeguards under section 504. And here's the, something from that guidance, for long-term exclusions, they said, you've got to look at all of the IDEA procedural protections that would normally apply to changes in placement. But this didn't really answer the question, okay? Because the question was, that question seems to have to do with individual COVID-related exclusions. Like if we're going to take one kid and we're going to move him out of school because let's say he's infected with COVID. The question that arose immediately is, does this guidance apply when you're taking all of the students with disabilities and you're moving them wholesale to online instruction? Does it apply when every kid is moving to online instruction? In other words, if in the case of a general closure, is this a change in placement with respect to every IDEA student? And it certainly would have been helpful for the Department of Education to answer that question, because immediately all kinds of ideas came out when this happened. I wanted to quote, to talk about a little case that happened a while back where the Ninth Circuit Court of Appeals dealt with a similar thing. I've worked with the state of Hawaii for quite a few years. And back in 2010, I remember that they had a big budget crunch and they just decided, no Fridays. We don't have school on Fridays. Nobody has schools. We're sending the kids home. We're sending the teachers home. They called them furlough Fridays, okay? And parents immediately sued and said, I'm filing for due process. And now stay put is invoked. You can't make this change. And the court said, it doesn't seem to us that the stay put provision or change in placement procedures were intended to apply to system-wide administrative decisions, but rather to individual student decisions. But they said, well, we actually think that under IDEA, a change in educational placement means where you're moving or changing settings. And in this case, they said the student settings is exactly the same. They're just having class one day less per week. And they said, we don't think that this is in conflict with IDEA because we're not singling out the special ed students. All of the students are missing out on Friday. I have a retort to that. I bet Ms. Goetz is thinking, but missing Fridays is going to impact the students with disabilities disproportionately with respect to students without disabilities. So that last statement would appear to indicate that since IDEA students aren't singled out, that these wholesale changes to online instruction that happened during the closure, or hopefully not, but that could happen if we have another pandemic strike, are in fact not singling out the students, and it's not a change in placement, rather it's a system-wide administrative decision. But the situation in Hawaii was a little different because here, there was change in settings for the special ed students. For every single one, they moved from some sort of brick and mortar setting within the continuum of placements to online, and that's a big difference. This idea that you just can take the child's program and poof, make it online, and that's it with no changes, and it's just the same thing. It's just a change in location. I think that's bunk. It's a fundamental different way in providing the services. It's a totally different modality of instruction. It's a total different animal to provide services online. So actually, most state education agencies took the position that when there were school closures, these wholesale moves to virtual were not changes in placement. The arguments were rather wonky, I must say. Some state education agencies said, well, it's just a change in location. I don't like that. It's more than a change in location. While some agencies got, I think, closer to the right answer, which was, well, all students are moving, so it's really not changes in placement for particular students under IDEA. However, I think that if you have future school closures, either you're going to have to do some process like IEP amendments to create some sort of continuous learning plan and provide prior written notice to make sure that parents participate in the process of moving students from in-person instruction to virtual. The means to afford parent participation within the framework of IDEA in a situation where you have wholesale school district closure remains unclear. Okay, we're not sure. We're not sure exactly how this happened. Okay, what about moving individual students between in-person and virtual? Not wholesale, moves of one student at a time. Clearly, these to me are changes in placement. I think Ms. Goetz would agree. These require IEP team action. Maybe so you could substitute it with the IEP amendment process properly done and prior written notice. And the OSEP return to school roadmap appears to indicate that this is the case, and that the placement decision, like other placement decisions, would be subject to the LRE requirements. And you might have to revise certain IEP components in light of the change in setting. Hey, I want to raise a question that there's not a good answer to. Where does online instruction fall in the continuum of LRE and restrictiveness? Okay. Some courts take the position that it's akin to homebound instruction because the student has no physical exposure to anybody. In the roadmap, there appears to be some indications that there's sort of a continuum of LRE within online instruction, and that if the online program affords some level of interaction with other students, albeit virtual, that's less restrictive than the child being completely alone with no interaction with anybody. What is my answer to this? We're guessing. Why? Because the IDEA legal framework never envisioned online programming. I happen to think that, yes, that online programming is part of the continuum of placements if it affords some level of virtual interaction with students. Then it's less restrictive than a pure homebound placement where the student has no exposure to any student. Okay, and I do think that those two are different in terms of LRE, but it's going to take real court cases, and it's going to take an IDEA reauthorization to really talk about that in a meaningful sense, in a way that we can understand it. Because right now the legal framework has fallen behind. We haven't had a reauthorization in 18 years. Well, see, a baby born in the first reauthorization would be an adult today. That's a really long time between reauthorizations. Okay, away from the process issues, let's talk some substantive issues in virtual placements. What if we decide as a school that there's some value in maintaining some online instructional options post-COVID, even if we don't need them? Even if all the students potentially are ready to come back to in-person instruction, have we found some value for some students in online instructional options? These existed prior to COVID, okay? And students with disabilities participated. So my question is this one. So if there's an online instructional option, is it a parent option for the child with disabilities under IDEA to participate in this program, or is it an IEP placement decision on a particular setting within the continuum of school placements? And I think that that's the better answer, that the better way to fit this type of idea within the IDEA legal framework is that it's the IEP team that decides. The parent can request, I want online instruction. I want the virtual program. I don't want my child to go to school, but that the decision ultimately is made by the IEP team as a valid placement decision, as a placement decision that considers LRE and considers the student's needs. Why? Because I think that the online setting is not appropriate for all IDEA students. I think that COVID has borne this out. There are certain students with certain characteristics, and their needs simply just conflict with the unique nature and modality of online instruction. And that shouldn't surprise us. There's no setting under IDEA that meets the need of every student. That's why we have a continuum of placement. So it shouldn't surprise us that online instructional options won't meet the needs of all students. So what kind of factors do I think are important for the IEP team to look at in determining if this student is going to sink or swim? If the virtual program is actually going to be contrary and contraindicated to the provision of FAPE to the child. Well, I think if the student already has attendance problems or school avoidance, I think an online instructional option facilitates school avoidance. Because you don't have the student actually in settings where in a structured environment, you're entirely dependent on the student in terms of their attendance and or the parent in terms of supervising if the parent's available. But I think that other things are important. Can the student remain on task with minimum prompts? I think students that are good independent workers will work out better in an online program. But students that have little independent workability are going to work worse. Social skills deficits, how are you going to work on social skills in an online environment? Some people have told me everybody socializes online nowadays. We're sort of, that's a main aspect of human interaction right now is online. Maybe I'm old school, but there's something to that casual and spontaneous physical interaction that occurs between students and in group instruction and group activities. So I think that students that have a lot of social skills deficits, maybe this isn't good for them. Also not kids that need a lot of one-on-one or a lot of life skills hand-over-hand instruction, students that have motivational issues. I think here I put an asterisk by this one. I think a factor relevant to whether online instruction is going to work with your child is how has it worked when he was on online instruction? That's super key. If it was a disaster, continuation of a program under which the child didn't progress doesn't seem to make sense. How willing are the parents to play a supervisory role in ensuring that the kid logs on and ensuring that the kid stays on? Because you think the role of the parent changes a little bit with online instruction. Does the student show compliance problems or emotional problems? Do they have the requisite academic ability and ability to work with the technology to participate in the online program effectively? For some students, I think the answer is they're a good fit. They're a good fit and they can be instructed pretty well, maybe even optimally in an online environment. But I think for some students, the idea is this kind of placement is just not going to work, okay? And I think for schools, what I kind of fear is that agreeing to a placement, to a virtual placement that we know is going to be inappropriate because of the student's unique nature and the nature of their disability, it's going to generate problems. You're going to see lack of progress. You're going to see the parent reaching like, oh, bring me in-home services, which is kind of opposite to the idea of online instruction is, but you don't need in-person services. When you start, but you're going to start getting these requests for, well, I want the virtual program, but I want people to come to the home as well. And also, I think that you may encounter difficulties moving the student back to school if they get overly comfortable with the online instruction. And I've had this happen with some of my clients' kids. They just have gotten too comfortable just being at home and jammies and just kind of going to school and not having the structure of the school environment. And I'm not so sure that that's a good thing. Maybe you could try a trial placement, see how it does, and then you make a permanent decision. What about students that are reluctant to return to live instruction because they have underlying medical conditions? Oh, I skipped one. I'm sorry. I think we know from CDC that some students with certain conditions are the kind of students that if they get infected with COVID, they could suffer really serious repercussions. I think determining whether that student needs to be served remotely requires looking at physician information. How has the student performed in online learning? How severe is the underlying condition? Does the school have safety precautions in place? This is less important now that COVID is waning, but it sure could come back or could remain. What's the position of the local health authorities? What are the LRE considerations? This has to be thought about. I do think that refusing to even consider a remote learning option with kids that have a high-risk condition would likely violate IDEA in Section 504. And I put in my notes that this has already been the subject of litigation. Texas, Pennsylvania, Kentucky. In Texas, where schools were prohibited from imposing mask requirements, parents sued because they said, this is forcing us to have to do online instruction because we can't safely send the kids to school because nobody's masked. Few of the kids are vaccinated, and my child will be at severe risk. And some of this litigation is still percolating, although it's likely going to go away. So IEP teams are going to have to, with kids with these health impairments, balance FAPE and placement and LRE and the health considerations, because I do think that Ms. Goetz will agree with me, health and safety are not a different or outside of FAPE. I think health and safety is part of FAPE. If kids are in an unsafe environment, that is part of FAPE. I think kids with disabilities have a right to an equally reasonably safe environment in the school setting. And I say reasonably safe because no environment is safe, completely safe. But I think they have a right to an equally reasonably safe environment. And OCR has actually said that with respect to Section 504 students. Okay, difficult situations where parents adamantly oppose a return to live instruction, but the student has not done well in remote instruction. And I've had situations like that. So just some thoughts as to the difficulty here. I think thankfully these problems should lessen as more and more counties in the US fall into low risk classification and infection rates wane. More parents are going to be comfortable sending the kids to school, and if they had concerns at all, and the schools are going to become safer in terms of COVID altogether. Okay, some words about comp. Ms. Goetz talked a little bit about comp, and I want to kind of continue this. Yes, we were told by the Department of Education, if you're going to miss services and the kids are going to decline, you're going to have to consider compensatory services. It was an open question exactly how courts were going to kind of apply this in the COVID context. What are compensatory services? It's what Ms. Goetz told you. Basically, it's back FAPE. I think it's like back taxes. If you didn't pay your taxes for 2015, then you owe your 2020 taxes, plus you owe your 2015 taxes. Those back taxes, that's the compensatory. So you owe the student his current FAPE, but you owe him back FAPE. That's the compensatory piece. And in the COVID context, I like to call it COVID comp. Some states and districts have decided to give it fancy names, recovery services, supplemental COVID services. That's South Carolina. It's compensatory services, guys. That's what the Department of Education called it. And it quacks like a duck. It waddles like a duck. It's got a big yellow beak. Okay, it's a duck. Okay, it looks and acts exactly like compensatory. And I think all of the universe of cases that discuss compensatory apply. By the way, back to this OSEP roadmap. Curiously, the roadmap says we're not clear as to who makes the COVID comp determination, but in another part of the document, they said it's our longstanding position that IEP teams make the COVID comp determination, and I totally agree. I think that's the right thing. Addressing COVID comp requires dealing with some complicating issues. One is, this surprised me. The percentage of parents that simply said, we're not going to do any participation in any alternative online instruction, no matter how much technology we have. We don't want it. Don't call us. We don't want it. Okay? It surprised me how many that happened. Should that weigh against providing compensatory services later? Because obviously the student didn't avail himself of the services. And the other is, I think that we put some students obviously on online instruction that are the very type of student that I indicated, due to their disabilities, are not going to work well in the online program. And what do the cases say? Well, the cases say ultimately compensatory services is an equitable remedy. That's fancy attorney speak for fairness. It's a fairness-based remedy. And to federal courts consistently, a parent's conduct, such as refusing services, not availing themselves of existing services, is relevant in determining comp. Now, I'm not talking about parents that couldn't avail themselves of service. I'm talking about parents where the services were there, the technology was there, but they just refused for whatever reason. They just didn't take advantage of the services. And I cite the Ninth Circuit in the Puyallup case. The school district lost the case, but the parent had rejected a bunch of services, so the circuit court reduced the compensatory award because of the parent's conduct. In Garcia, out of the 10th Circuit, that's your circuit, there was a FAPE violation with a young lady who never came to school and never availed herself of services. And the court said the limited resources we're giving schools to do services, and we're going to make this school provide comp ed on the chance that this child might decide to attend school because she affirmatively avoids it. No. And they said no compensatory in that kind of situation. And there's other cases of the similar idea. And the similar idea being, if you don't avail yourself of services that you legitimately could avail yourself of, it's going to count against you. Check out this case, Hutto ISD, case near here in Austin. I didn't litigate it. But anyway, this parent and the school worked on getting the student services during the school closure period. They held 9 IEP meetings, a variety of efforts to keep the student engaged, and he did well. He made progress, passing marks, mastered all IEP goals, showed progress in his dyslexia program. The parents still sued, insisting that they felt that a FAPE meant that the student should be reading and writing at grade level, and sought compensatory services. Even though the student arguably didn't need comp services, the IEP team offered a package of compensatory services in reading and speech, which the parent promptly refused. The hearing officer said, the student doesn't have to meet performance standards on par with non-disabled students. That's not necessary for FAPE. What's necessary is appropriate progress in light of the child's circumstances, and that's what happened here. And the hearing officer also said, I think that the parents' claim for comp is undermined by the fact that they actually declined the services that were on the table. So the hearing officer denied relief. I won't go over this qualitative versus quantitative analysis other than to agree with Ms. Goetz's position. The quantitative analysis is if you miss 4 hours of speech, you get 4 hours of speech. And the qualitative analysis kind of looks more individually. It's like, well, how much skill did you lose? And what is it going to take to get you back to square one? And I agree with her position. And it's the federal court's position. Notice these cases that say that the qualitative approach is actually more in line with the individualized approach of IDEA, which is exactly what she said. More difficult to apply, I must say, because you still find hearing officers relying on the quantitative. Why? Because it's easy, super easy to calculate. The qualitative, that takes some thought. But there's courts. The DC Circuit is the circuit that has most compensatory services jurisprudence, and they say that the quantitative analysis is cookie cutter, and a child isn't entitled to an hour per hour compensation. It's just what is it going to get them to be back to where they need it to be. I was interested in this Colorado case where the hearing officer said, we think actually the quantitative approach where you provide minute-to-minute compensatory can be burdensome on some students because it's just going to overload them to the point that it's overwhelming. So generally, what do we say here? The courts, I think, should apply more of the qualitative analysis. And I think when IEP teams are making the decision, they should also kind of decide on the qualitative based analysis. On COVID comp, I think probably it's best if IEP teams consider COVID comp for all students, maybe. But definitely, I think you should really consider COVID comp for students if their initial evaluations were delayed and they were eligible because they missed out on some FAPE. Were services actually completely missed during closure? Okay, I mean, you missed the speech. You didn't even get a replacement online speech. You just didn't get speech. Student didn't make the anticipated progress. Student failed to fully engage in virtual due to disability. If the parents are requesting comp, I think in all of those situations, meet and make the determination. By the way, I wanted to point out that the OSEP roadmap says COVID comp services may be necessary even if the student properly graduated. And I think that's correct. I think that's in line with court decisions that say, and if the student missed out, even after graduation, they might be entitled to some services, some other compensatory services. Or like I said, you could decide wholesale, we're going to have COVID comp determinations on all students. And if you think that the student missed out on services or really failed to make all anticipated progress in any area, I think that you passed like part one, which is yes, COVID comp is warranted. And the next step, step two is, well, how much and what? Should it be after school? Should it be ESY or should it be, let's not call it ESY. Should it be a supplemental summer program? Should it be increased services during the day? Should it be a combination of the preceding? I think that's all IEP decision-making. But I think some guidance that I would offer here is that whatever your comp package is that you're going to offer should be set out with the same amount of specificity as the IEP services, meaning a high degree of specificity, a specific commitment of resources on the part of the district. If the parent declines the compensatory services package, I think that the IEP team should document the package, indicate that the parent is declining. And I do think that the parent can change their mind. I've been asked, for how long can the parent change their mind? I don't know, probably as long as the statute of limitations period for due process hearings. But give the parent a chance to change their mind about this. I think that the idea is as Ms. Goetz indicated, the focus is going to be on whether the compensatory COVID comp package is reasonably calculated to put the student where they should have been if COVID hadn't happened. That's the goal. That's the goal. And you should be able to tell what kids just are markedly different post-COVID in terms of their performance, where they just haven't made the anticipated rate of progress, or worse yet, where you've seen some regression. And those are the kids that are just screaming, things didn't go well for me during closure, and I need COVID comp. And I'd be kind on that. I mean, even on this, I'm going to say, even if the parents really were not wise and did not avail themselves of all the services that were available, be kind and offer the kids something. Okay. I mean, even if legally the parents might have kind of soiled their remedy in terms of compensatory services, I think kindness is probably a good word to use during this unprecedented time. Relevant factors in determining the comp. The roadmap says, where's the child performing now? What was the previous rate of progress? What were the services you provided before the COVID disruption? I want to add some. The progress reporting data during the COVID disruption, I think that's super important. Whether the student took advantage of services, the reasons the student didn't take advantage of the services, and whether once the student came to school, whoa, they recouped. That can happen. We've seen it. The student within just a few weeks, wow, back to the structure of school, and they just have shot up back to where they needed to on their own, a natural recoupment type of situation. And previously I skipped a slide where the Cheyenne case said, no compensatory is warranted if just by natural recoupment, the student is back to where they should be. And I am through with my comments, and we'll welcome your questions. I saw in the chat there that you had lots of questions, and I'm going to be really interested in them.
I couldn't unmute myself. All right. Well, thank you, Jose. That was wonderful, and always a pleasure to hear your presentation. Amy, I will now turn the time over to you for your remarks.
Thank you. I'll try to be brief. I love the word kindness. I also love the word generosity. I am seeing what I think is a very parsimonious response to requests for compensatory services, at least in my state, with parents I talk to. So the procedural requirements, Mr. Martin doesn't think I want to see that go away from Rowley. Well, it's not a product of Rowley, it's a product of the IDEA. Procedural requirements are embedded. They're a very, very important part of the IDEA. They have their genesis in the Constitution and the right of citizens to due process. I'm not sure in the discussion of the ND case with the across the board reduction of school days is not a problem. That's an equal protection standard. And again, I think there's a lot of confusion about whether we're talking about a comparative standard between what kids with disabilities get and kids without disabilities get, not an individualized analysis that's required by IDEA. But one of the other things I learned in preparing for this presentation is that it's not so bad here in the 8th Circuit Court of Appeals. I always bemoan the fact I think it's a very conservative and often wrong Court of Appeals. I think it's been very modest in terms of its and sometimes hostile in terms of its handling of special education cases. I think that it has applied the de minimis standard. So for us here in the Eighth Circuit, the Andrew F. Rejection of that standard is welcome. But we also have a case called Hale versus Poplar Bluff from 2002, where our court said the stay put provision is literally and rigorously enforced, consistent with its purpose to strip schools of the unilateral authority they traditionally employed to exclude disabled students, citing to a U.S. Supreme Court case called Honig versus Doe. And there they looked at a school district's unilateral movement of a child from a home-based program to a school-based program during the pendency of a case, and found that that was a violation of the child's stay put right, transfer. And then they looked at some of the other cases where students are transferred from one program to another, and said a transfer to a different school building for fiscal or other reasons unrelated to the disabled child has generally not been deemed a change in placement, whereas an expulsion from school or other change in location made on account of the disabled child or his behaviors usually deemed a change in educational placement. There, the Eighth Circuit affirmed a district court decision, that this change of placement from homebound to school was a change of placement that implicates all of the procedural safeguards. The district court there had reviewed the impact of the change on this particular child, and the court saw it as an individual decision. With respect to the right to stay put versus the right to recovery, if services were impossible to continue during closures, I think is an interesting question. I think best practices seem to be to afford due process to parents through active communication, discussions, and decisions. Whenever there's a change of placement, whenever there's a change in services, that is the best practice. When I was a complaint investigator and worked at our Minnesota Department of Education, I was consistently taking the position, and I think it's still the right one, that schools should not walk along the edge of cliffs. That if there are ways to step back from the edges of cliffs in order not to stumble and fall down, that they ought to, that wisdom ought to guide them in taking a step back from the edge of the cliff and not taking the dangerous course. But in this instance, it would be to talk about, communicate, to convene the IEP team, have a discussion, make decisions. I think it's the best way to avoid disputes. It's the best way to maintain relationships. It's the best way to serve children. I think LRE in the time of COVID is likely a modified standard, given the risks of infection to students with disabilities. I think that part of the substantive issues in virtual placement, can parents continue to cling to virtual placement after schools reopen? I think there's a nuanced analysis at times. You know, we have parent choice in open enrollment, charter school placements, homeschooling. How does that play into the question of whether and when parents can elect virtual or online instruction? Is that online program run by a different school district? I think that other factors relevant to the appropriateness of online options include district staffing to support children at home as needed, masking of students and staff at school and at home as needed. I think there's an interesting question about the medically fragile student and whether or not she's entitled to go to school and expect that those around her and in contact with her will be masked, even if that's not a requirement school-wide or county-wide or in her region. I don't think a trial placement's identified in the IDEA, and I think that there may become stay put implications. I think we have to think about services and supports for those students who are having a difficult time returning to online instruction. What services and supports are returning to in-person instruction? What services and supports can we bring to bear to facilitate their transition back to school? Can we identify and respond to the causes of the reluctance? I think districts can establish standards and procedures to make decisions about what to do in those circumstances. I think it may require reevaluation and IEP team discussion. I think that teams can consider enhancing services to improve progress and participation. I think that it's not just missed services that we have to be concerned about in terms of addressing compensatory services, but anytime the quality or quantity of services has been diminished during this pandemic. The cooperative team process, I think, is most likely to reduce disputes and maintain relationships. Equitable factors, these fairness factors that Mr. Martin talked about, they've always uniformly been considered in comp ed, compensatory education determinations. Another factor is staffing shortages. I think there's a real question of whether parents can give away their students' rights. Can a parent waive the student rights, or are they separate? Can the student assert their rights even if their parents have decided for whatever reason that they won't take advantage of and leave on the table some offer of services? Attendance problems are educational problems. They have to be identified. They have to be evaluated. They have to be responded to. Lack of participation, lack of engagement are critical problems. We have two cases in the 8th Circuit, one that I was involved with and one that I was not, but I love the language from this case, DL by Landon versus St. Louis City District's School District, where the court, where the student declined to go to and engage in the receipt of sensory supports. And the school district argued that the student therefore did not have sensory needs because he declined those supports. And this is what the court said, quote, all children, including those with autism, sometimes refuse things they need. This rejection does not diminish the need. Rather, it demonstrates that sometimes children are not the best judges of what is good and necessary for them. Sensory support is treatment, not an activity. An ill child may not prefer the taste of medicine and resist taking it, but that does not mean that the medicine is unnecessary. And the other case is EMDH, a case that I took in a Independent School District versus 283. It went all the way to the United States Supreme Court, where it was not taken by the court. And the 8th Circuit issued a very really uncharacteristically harsh assessment of the school district, St. Louis Park schools here. Mistreatment of this student, my client, who experienced some debilitating mental health, anxiety, depression, was unable to go to school. The school's response was, even though she was unable to go to school, they knew that she was struggling with mental health. They knew she was in and out of 5 different placements, 3-day treatment placements, 2 residential treatment placements. Their response was to talk her parents out of asking for a special ed evaluation because she was gifted and talented and so smart and a gifted poet that on those rare occasions she came to school, she could perform. She didn't look like she was anxious or depressed. And the district's response was to disenroll her 5 times. And the court made quite a note of that response, noted every time that the district disenrolled her. But there was no question that mental health is a disability, that schools are responsible for the mental health disabilities of students, where that impacts their educational performance in all domains, including attendance, and that attendance is an indicator that there's a problem that should be addressed and not ignored. Guarantees of grade level performance. There aren't guarantees of grade level performance per se, and however, there is a guarantee of access to state standards. A FAPE is defined by reference to inclusion of state standards. State standards include grade level performance. There now is a requirement of ambitious goals and challenging objectives in light of the child's ability, disability, and performance progress. I think qualitative and quantitative assessments are sometimes the same in the end. The better approach is to provide enhanced services in the IEP rather than piling on additional comp ed. We have another Eighth Circuit case, CN, where the court recognized the current school district's obligation to provide a current FAPE includes services to address prior deficiencies, which I think is right. I think there are two fair assumptions when we are looking at the issue of compensatory services. One, the services on the last IEP that the student's IEP team decided were appropriate and necessary in order to provide the progress that they need. So those services before the COVID shutdown represent the scope of services required for a FAPE. And the second assumption is non-delivery for whatever reason denies a FAPE. I think those should be the assumptions, and that those are the students, when those circumstances exist, that we have an obligation to pay particular attention to with respect to the impact of COVID. Best practices are, I think, if any services aren't fully delivered in the original amount or in the original method, we ought to be assessing compensatory education. We should be clear to clarify that recovery services are just that. In IEPs, they're recovery services. It will avoid a question of whether those services are part of a current FAPE, part of a stay put IEP, and that additional needs arising due to COVID changes include mental health services. Thanks.
Thank you, Amy. I could honestly sit and listen to both of you all day, go back and forth with those things, because I think there's so much that we could continue to go deeper and deeper into these issues, right? So I'm gonna just pause for a minute. I do see people putting in the chat their not only their name but their email. So thank you for doing that. It will be important for Jennifer to be able to get your certificate of attendance back out to you. I'm also going to go ahead and just put in the chat, there's the link for the recording for when this is ready to go. And then I'm also going to put in the chat here right now the evaluation, just because I want to use up all of our time for the rest of the remainder of our time for questions and answers. Amy and Jose, I did go ahead and copy those and send it to you in an email, so that hopefully it might make it a little easier for you to see what those questions were. I think some of the questions may have been answered throughout your presentation. However, you may decide to go a little deeper in that. So I'm just going to go ahead and start with this first question. Are compensatory education services required when a district has made every effort to provide education services to a student, but the parents have not made the student available? So again, I think you did answer that, but if you want to go a little deeper.
Well, I take the question to be legally required. Are comp ed services legally required when, you know, the district's made every effort to make services available, but I'm assuming the parents haven't made the student available, and I'm assuming for no good reason, that this is really sort of a refusal situation. I did see quite a bit of that, more than I thought. I think legally required. I think, you know, I think the courts are pretty cut and dry on this, and they're going to say no, that parent conduct is relevant with respect to whether the compensatory services remedy is appropriate. However, I'd have to say that this is your student, and you want this student to do well, and it's going to be a shame if we're just going to be okay that for a significant period of time, the student actually received no services, and they're going to be significantly behind. I think that the IEP team should work with the parent, even though the parent here may have admittedly made a mistake in not accessing certain services, and now the student is more behind than they need. So here there's a difference between, I think, the legal and I think what is what is compassionate in light of the situations with students and with school districts.
And I don't disagree, except to say students have rights too. And parents don't always have the authority, nor should we give them carte blanche to give away their students' rights. And I think it's a practical question as well as a legal question. I think on the legal question side that there are hearing officers and courts that would recognize that regardless of why the student fell behind, that the student is entitled to recovery services. That's the whole concept of recovery services, that it doesn't matter why the student fell behind and lost the ability to make progress. And I think there are hearing officers and courts that would recognize that students have rights to recover lost progress, and that parents don't have the right to give that away, and that when parents come back to ask for those services, and that school districts have an obligation to provide for past deficiencies, including the deficiency that might be caused by the parents' unwillingness to make the student available. And I agree with Mr. Martin that there certainly has to be an inquiry about why the parent has not made the student available.
I have to say, I mean, the idea that regardless of the reason that the parents didn't avail themselves and the child didn't get services, it doesn't matter that compensatory services are legally required. I mean, the courts are clear that that's wrong. That if a parent has just chosen to not take advantage of services, that matters in the calculus of providing an equitable remedy. So the reason matters. That's the Puyallup case. That's all of the cases that talk about fairness and parental conduct, just like parental conduct is relevant even in a situation of unilateral private placement and reimbursement. And I also have to point out that I think there's very few situations where the parents, the students have rights that are absolutely independent and unwaivable by the parents. I think the parents can waive the right to FAPE. Why do I say that? There's a regulation that says that. The 2008 regulation that allows a parent to revoke consent for services by merely writing that on a piece of paper is clear indication that the federal government is totally okay with the parents just throwing away their child's right to FAPE. All of the commentary back then when that regulation came out was about whether the parents should meet some burden, whether the idea that parents act in the child's best interest in education is a presumption, but a rebuttable one. That was all that commentary was about. And they decided we're still going to go with this. We're still going to go with the idea that a parent can revoke consent to services and therefore completely disqualify the child from FAPE.
But I think we're in unusual circumstances here, Jose. I think that we are in the circumstance where the assessment of compensatory services and lost progress is a blameless environment. It was intended to not focus on. It's why so many school districts and states are coming up with creative ways to characterize what we call these recovery services. It's why the Department of Ed has made special attempts to say this isn't anybody's fault and this isn't focusing on blame. And so it seems inconsistent to me to be blaming parents for not taking advantage of services in an environment where we're supposed to be working cooperatively on creative solutions without blame.
I see one here that I'd like to touch, Ms. Smith. How does a parent initiate a request for compensatory relief when their charter school hasn't provided SAI and some speech language services to some high school students? I'm not exactly sure what SAI means, but that's got to be some form of service. Ms. Smith, can you help me with that acronym?
I was just reading that one as well. And so if whoever has posed that question, if you're still on, if you can.
Well, look, I'll generalize the question. How does a parent initiate a request for comp services when their charter school hasn't provided some of the IEP services to some high school students? I've got to say that I think the question is ill put because the parent shouldn't have to request it. I think that in these situations, it is the IEP team that should meet, that should actually initiate the discussion of COVID comp services, because there's an understanding that some services were missed during closure. And the Department of Education says that's okay as long as you provide compensatory services. But it shouldn't be on the basis of parent request. If there's been a denial of FAPE as a result of missing some services during school closure, then I think it's a duty of the LEA, whether it be a charter school or a public school district, to initiate the IEP team determination of whether COVID comp is warranted, and if so, how much.
I tend to agree, but I would go on to say the following. I think that if the school has not made an offer to assess and discuss the issue of lost progress or compensatory relief, that a parent initiates a request by putting it in writing, by signing it and dating it, sending it to the IEP manager or the special ed director, and asking for the IEP team to be convened to address and resolve the question.
I agree. My only point is that they shouldn't have to. They really shouldn't have to. That's really the district's responsibility. I see a question related to this. It says, in these calculations of comp, if a student's mental health has been a factor in a period of missed times, how does that work the determination of that student's benefits of catching up? And I think I made this point on one of my slides. I said, well, there's a complicating factor, and that is if a parent hasn't availed themselves of services, and we've gone over that. But I think there's also, if for reasons related to the child's disability, they've been either unable to benefit from online instruction in some form. And if the child really had really severe anxiety, and as a result, I think it's documented that they could not access the services that were available, then I don't think it's a refusal situation as kind of the cases discussed. I think that here the equities would weigh towards providing the child full COVID comp.
I agree. I think it's not an inability, or it's not an unwillingness, but an inability to access services. And I think that if that's the case, it has to be taken into consideration in the analysis of how the student was affected by the closure, and in particular, how to address directly and remediate the effects of the mental health.
A question related to this, I keep looking on in the question, is how about parents deciding to homeschool because online was the only way that services were provided for an entire school year, and the parent felt that the student couldn't sit in front of the computer for hours? All right, in most states, parents have a pretty unfettered right to decide to homeschool their child and kind of provide their own instruction and their own curriculum, as in my state, and I believe Wyoming. Normally, the traditional analysis here is once a parent decides to do homeschooling, they've essentially given up the right to FAPE from the public school setting, and they're now responsible for FAPE. Now, I do think that there's some questions of complexity, though, because if what the school district was offering was really not appropriate, and that's the reason that the parent declined it, the parent could still be entitled to compensatory services. But I'm just pointing out that the traditional analysis is akin to, I'm taking my child to private school and voluntarily, and I'm just saying bye-bye to public school FAPE. That's normally the formulation with homeschooling as a parental choice. But if what the school district was offering was inappropriate and not sufficient for FAPE, then I think there could be recovery for the parent.
I agree. And I think that in that instance, that where parents have homeschooled, perhaps even there may be a claim for reimbursement for the expenses incurred. So materials and other costs involved in homeschooling would have to be assessed, would have to be raised, would have to be discussed, should be a factor that is on the table for discussion, as well as how did the online programming affect the student? What is the data that of how the student responded to or did not respond to? How did it affect the student's progress? And I think also what benefit did they get from the homeschooling? And so what is the measure of and method of recovery services individualized to that particular student's need?
I'm glad where you were talking about the reimbursement. You said reimbursement for supplies and other costs, but I was waiting for time, right? Because that I think is not viable. I don't think that a parent can decide to homeschool their child unilaterally and get reimbursement for their own time in providing the services. And certainly no court has ever said that. And I'm not sure that'd be a good idea. But I do see a question kind of towards the bottom here, and I think this is a doozy. Will the initiation of compensatory services due to COVID for students who didn't participate in offered services ultimately be extended to non-COVID related excessive absences in a post-pandemic setting? I do think they're different matters. Okay. I think COVID presents extraordinary situations and placed extraordinary pressures on parents. And I disagree with Amy on the point that if a parent utterly failed to avail themselves of services that were right there and were appropriate and the student could have taken advantage, I think legally that matters. And I think courts, particularly in conservative courts, would say, sorry, you bought this, you made the decision, you've got to live by the choice of your decision. And parents can make choices for their kids that can be ultimately turn out to be a bad thing. I don't think the IDEA protects students from their parents' bad decisions, like I indicated earlier. No way. I don't think so. Now, post-pandemic excessive absences, I agree with Ms. Goetz that attendance or lack of attendance or absenteeism is a behavior. And it's a behavior that impedes learning, okay? And regulation 34 CFR 300.324 says that's a special factor you have to look at. If a child engages in behaviors that impede their learning, then you have to address it with positive behavioral support. So I think when you have attendance issues, whether they're due to disability or not, you need to address them through services, through the IEP as best as you can. You need to address them with behavioral interventions. You need to address them with support services, maybe parent training and parent counseling, address them with student counseling and these types of supports. But I do think that we have to live with this fact. If we have a student that is adamantly boycotting his education and doing it contrary to their parents' wishes and contrary to the best efforts of the IEP team, then it may be an issue where a FAPE has been offered. The FAPE is there, okay, including all of the services that would enable the student to participate, but the student is just refusing to avail himself of his free and appropriate public education. And certainly a student can throw his right to FAPE away if they really, really want, okay? So I have to say the IEP teams must address absenteeism and attendance problems. You can't just in a facile way simply say, oh, the child is just not attending because he doesn't want to, and that's it. No, I think you have to continue working with the child on their attendance issues without an end. I think you can't quit on those issues. But the point that I want to make is there are situations where despite anybody's efforts, the student's not going to participate in the educational process. And that can happen. I've seen it.
Yeah, you and I are going to disagree on this one. I've not seen that happen. There's always a reason why kids are refusing to go to school. It's just a matter of figuring out why that's happening. Just like with every human behavior, there's always a function to every human behavior. And if we don't understand why it's happening, we'll never get about the business of attending to it. And so I think when children don't come to school, school needs to come to them. And we've had a lot of situations where kids are not coming to school for a whole variety of reasons. And the way not to honor the function of what is typically avoidant behavior is to continue to bring education to them where they're at and facilitate their return to school by not letting them escape the instruction that they're avoiding.
They can escape it. Their home has windows. And I'm saying this because I'm remembering a case where the student wouldn't come to school And against what we thought was appropriate, the parent talked us into homebound instruction, and quickly the student said, I want homebound instruction. And as the homebound teacher was coming in, he'd leave the window and run away. Okay, they can escape instruction. Okay, you can't chase them. They're faster than us.
But we're smarter than them.
Yes, we are. But human will is really, really strong, because at times that the avoidant issue is, the young people, what you can't kind of inject into them is the understanding of the value of education. FAPE is something that ultimately, I just don't think it's an injection. Okay, I just don't think it's all about the adults. Education is a process of receipt and delivery. And there's got to be at least some desire to receive, some minimum desire to receive. But ultimately, it's not an injection. It's not a little pill that you put in there. I've had parents tell me, in a residential facility, they can be forced into the educational setting. You can unwillingly force them physically into the setting, but force their mental participation? Absolutely not. You can't do that.
No, but I think we're smarter than them. I think we can figure out how to cajole them, how to facilitate their participation, how to reach them and engage them. And we can't do that if we don't understand why it's happening. I've never met the student in 30 years of doing this work who really doesn't want an education. Never, not one. They may look like they don't. They may sit at school with their hoods on their heads. They may be voting with their feet and leaving school, or refusing to come to school, or going out the window when the teacher's coming in the front door. But I just don't believe that there is a student who doesn't want to learn. And I think it's the obligation, the duty of adults in education to figure out what the barrier is that is standing between a child who's not accessing education and their education.
And in the minutes that we have, I kind of tend to agree with the idea that innately kids want to learn. I'm just not sure that all students are invested in learning what we think they need to learn: the maths, the science, the writing. I don't think that all kids necessarily think that there's value in that. And I don't think that legally what IDEA requires is that just the right magic way to approach it be found and divined. I think it just requires an approach that's reasonably calculated so that the student wants to take advantage of it. But I think the student can thwart it. And I think there can be situations where courts and hearing officers say, we really can't think of more within the concept of what IDEA provides for, which is a floor of opportunity. I don't think that has really changed with Andrew, and that the school has provided it, and the student, the FAPE is there. The FAPE has been offered. It's provided. It's there for the taking, and even the extra stuff that would be designed to help a student understand why he should take advantage of the services. But I have seen some students where the lure of working and of not being hamstrung by the structure of the school setting and of just kind of learning things on their own and things that they see more value in. I have seen that type of student.
Yeah, and I also have seen fabulous experts figure out how to motivate the kids who are really hard to motivate, and figure out how to join them in whatever their interests are, even if they aren't what we, typically think is what their education should be about.
Agreed. But ultimately, I think that we can draw some valuable points from all of the presentation and that is, we know that some students will have declined during the period of COVID closure. I think those students deserve a fair shot at a calculation by the IEP team of a compensatory services package. And By the way, it doesn't necessarily have to overburden the student with after-school services. It could be some summer services. It could be enrichment of the existing IEP services. It could be a combination thereof. Because I do think if you overload the kid, there's diminishing returns at time. You want the kid to go to school 2 hours a day after school, after a full 7-hour school day? That's probably unrealistic. But I think kids deserve a fair calculation of this when we know that they have declined, and that they deserve that the IEP team put their heads together and figure out how that's supposed to work.
And the department guidance that really hit home with me and has stayed with me is that accelerated learning and tutoring are and providing those recovery services during the child's school day are the most effective means to bring them recovery services.
I just have one follow-up question that just, I think just to make sure that they're being covered legally, just as long as when these kind of things happen, I mean, I just want to throw out there, and I know you guys will back this up as far as like, where should they put this information? Making sure that all of this is not overly, but just well documented in a prior written notice, to ensure that, you know, if it does end up going to a state complaint or to due process, that the best way to cover themselves is to make sure that they have documented all of these things, what the offerings have been and what's been refused or denied in a prior written notice.
I mean, I think there should be a piece of paper, and the piece of paper should say COVID comp package on top. And then it should state its components, precisely what enrichment of services is going to be allocated to COVID comp, what missed services are going to be there, what summer services are going to be there, and they need to be specified, the frequency, the amount, the time, the location, the duration. And I think that needs to be made really, really clear. I do think that you can have enrichment of IEP services serve as the COVID comp, but I think it's best to identify what the enrichment part is as opposed to the baseline part, in case there's a later disagreement.
I also think the other components of the prior written notice are required in that instance, and that is to identify the basis for the determination, what factors were considered, what other options were considered. So cover all the bases.
Correct. Now that's a prior written notice. I see two different things. One, there should be a document created by the IEP team that sets forth that comp services package. The prior written notice, it's going to explain that a package was the decision made by the IEP team that a package was going to be put together. The package was provided. The basis of the package, generally, whether quantitative or qualitative, a combination thereof, options that were considered, and other factors in the process. The prior written notice is just a re-explanation in writing of the decision-making that happens in the IEP team.
Well, Amy and Jose, again, what a wonderful session. I feel like, again, I could sit and listen all night, but I do want to be respectful of your time, as it is later there than it is here in Wyoming. So I want to definitely make sure you get back to your families. Thank you so very much. And I know that many people are just waiting to see this recording again. I know I am one of them. We'll go back and watch over and over. And again, thank you so much. And thank all of you who have taken time out of your day to join us. And we will see you soon.
Happy Easter, everybody.
Thank you all. Thank you, Jose. Thank you, Dina.
Thank you, Amy. Good to see you.
See you soon.